Good morning, everyone. Good morning to all attendees. Thank you very much for joining today's webinar on managing your patent under the Patent Cooperation Treaty. This is a collaboration between the International IP Help Desks initiatives of the European Commission in cooperation with the European Patent Office. It's great to have you all here. It's a training that's specifically of interest to SMEs on better understanding how to manage their patents. Before moving on to the content of this webinar, I briefly want to give you an overview of today's agenda. So we'll start with the importance of a patent strategy. Why is it important? This is followed then by managing your patents under the PCT, highlighting some advantages and disadvantages. This will be covered by the IP business advisor of the Southeast Asia IP SME Help Desk, Mr. Benoit Tardy. Then he will also cover international filing procedures, looking specifically at Latin America, China, India, and Southeast Asia, looking at fees, how much does it cost on average, and how do you file your patent. And last but not least, from 10:30 till 10:50, we have Camille Rémy Boliolo from the EPO with us today, which is great. Thank you for joining, who will cover specifically the role of the EPO in this process, followed by a Q&A. I would very much encourage all attendees throughout the presentations to share any questions they might have, either in the chat or in the dedicated questions box. And we will cover those at the end of the session. We're also joined by experts on the specific regions. On India, we're joined by Hanna Underkova, who's the IP business advisor there. We're joined also by Cesar Fernandez Elvira, covering Latin America, and by Matthias Zubimendi, covering China. So if you have any specific questions on either of the procedures in these regions, we've got the experts with us today to cover those questions. Now, before I give the floor to Matthias, just a few words on the help desks, the international IP help desks. What we offer is free of charge, first-line confidential assistance on IP protection, management, and enforcement in complicated third markets. So we are really there to support SMEs in making strategic and informed decisions regarding their IP assets. So if you're an SME or a startup or even a business support organization working with companies that are dealing with India, Latin America, Southeast Asia, or China, we are very happy to cooperate with you and to organize some trainings maybe together in order to inform as many SMEs about the importance of IP protection and enforcement. Just a quick overview slide of the actual services that we offer. We offer an inquiry helpline, which is a physical email address, in some cases a phone number that SMEs can call at any given time and write to with any question on IP. These can be basic questions such as how much does a trademark registration in India cost, to more complicated questions on, for example, tech transfer between Europe and Brazil or China. As I mentioned, we organize a lot of training workshops, both online and on site. We have a website, a dedicated website, a bit more on that later, with various blog articles, news articles, and basically a wealth of information regarding IP through numerous guides and fact sheets on topics such as patents, trade secrets, fact sheets per country, and industry-specific guides as well. Just a few examples of the materials that we've produced and that are available on our website. On the left, you see an infographic on protecting trade secrets in China, an IP country fact sheet for Argentina, and an industry-specific guide for Southeast Asia on the ICT industry. This is just an example of what we cover and what we have freely available for SMEs, but there is way much more to see on our website. So I strongly encourage you to have a look on our website. I would also encourage people to follow us on the usual suspects, Twitter, Facebook, and LinkedIn, where you will receive updates on new materials, new IP legislation coming through, and various tips and best practices for SMEs. And as I mentioned before, you can find all of us on our new website, ec.europa.eu/IP-helpdesk, and that's where you find all of the regions. So just to sum up, there's 5 IP SME help desks. There's one covering IP in Europe. It's a European IP help desk. We have the China IP SME help desk, which in addition to China covers Taiwan, Hong Kong, and Macau as well. We've got the India IP SME help desk, Southeast Asia, covering all of the ASEAN countries, and Latin America, covering a lot of countries in the Latin American continent. And it's good to mention that soon we will also be joined by the Africa IP SME help desk, so keep your eyes open for that. Without further ado, I would kindly invite Matthias to cover the next slide on the importance of a patent strategy. Matthias, the floor is yours.
Thank you, Jim. Welcome, everyone. I'm going to speak about why it is important to have a patent in order to design a more complex IP strategy, a protection strategy. The first aspect why it is important to have a patent is because a patent, at the end of the day, it's a monopoly over a product or a process. They will give you exclusive rights over certain specific acts. You will be the only one capable of manufacturing the product, of selling the product, import, export the product. Having that monopoly gives you, of course, a considerable advantage over your competitors. A second advantage is that will improve your reputation. When you are a company that is well known for its technology, for its innovation, and you have several patents, well, the reputation among your partners, clients will be increased. So your company will, when negotiating, will be in a much better position. That will also strengthen your market position. You can use the patent as a method of marketing, of promoting yourself, showing your company as an innovative company, showing those type of values of being always at the front of the technology will be useful for you to promote your company. It will grant you more commercialization options because you will be able not only to manufacture but also to license. In the case, for example, of China, you will also have the chance to have an open license system in which you can simply open the license, open the technology and the patent to everyone interested in a license, and that will make the negotiation way easier. That, of course, will also boost your negotiation power. Since you will have the exclusive rights and the monopoly over certain acts, you will be the one capable of using this as a tool for negotiating and for obtaining a better agreement. Jim?
Jim, you're muted.
Thank you, Cesar. I would now kindly invite Benoit to cover the section Managing Patents under the PCT and to talk about advantages and disadvantages. Benoit, the floor is yours.
Okay, thank you very much, Jim. So let's talk about the advantages and disadvantages of using PCT. So first of all, you see on these slides, there are 8 advantages. So the first one would be what we call multiplying effects. In fact, the PCT is a very nice and useful tool, and it will help you to seek patent protection simultaneously in a very large range of countries. In fact, it's 153 contracting states with the PCT. It will help the applicants to secure potential markets, and at the same time deferring major costs derived from separate patent application in each of the countries of interest you will select. The second one is upfront information. Many people do not know about this, but the applicant may receive a fast and reliable first opinion on concerning prior art and the patentability also of the invention already in the international phase. We will see later on the different steps: international phase and national phase. There is also this. The third one is the amendment mechanisms. So several procedures during the international phase allow applicants to amend the application, and this is done for overcoming potential objection which could be raised in the opinion on patentability, and enter to dialogue with the patent examiner. The fourth one may be additional searches, additional searches or additional time. The additional searches is, and in addition to what we call the international search report, you may, as an applicant, obtain further this is all optional, but further reports and written opinions on the patentability of the invention. Additional time is when you look at, for example, the Paris Convention, which give the applicant 12 months to claim priority on the first application. The PCT may provide you up to 19 to decide in which country you will months then decide to pursue the grant of your patent. There's also a significant time which is allows you to also to decide about the geographical scope, and you may postpone the decision up to 30 or 31 months. This we will also see later on during the webinar. The sixth advantages is it's a very fast track procedure. So there are numerous bilateral agreements under what we call the PPPH, the Patent Prosecution Highway. And this is the acceleration of national or regional procedures and based on a PCT application. The seventh advantage is the flexibility of this procedure. So you may request an early entry into national phase at any time before the expiry of the 31 months since the application date or priority date. This may be also discussed later on. And we also have an overall cost effectiveness because the PCT procedure allows applicant to request several options like the written reports, but also you are granted information to assess all the way for the patentability, the potential scope of protection before the major filing and prosecution costs are incurred. So it's like a centralized prosecution before a single patent office and simplifying procedure and reducing costs. So this is where the advantages. So we will now check on the disadvantages. Okay, so the disadvantages, of course, there are less numbers, and I will try to go very quickly on this. So in fact, one of the main disadvantage is that the PCTs, we say that it's only applicable to the registration procedure. So it means that the international PCT procedure does not result in the grant of a patent per se. Applicants, you will have to still prosecute the applications before regional and also national patent offices in the countries you would like to seek protection. The second disadvantage is that at the end of the procedure, the costs might be higher. And why? Well, it's very simple, because at the PCT international filing and search fees are added to the costs and the fees related to national phases. We will see later international phase, national phase. And moreover, there is also the fact that the overall cost for obtaining patent rights in some countries may be higher. The third disadvantage is that some countries, unfortunately, and territories are not yet covered by the PCT. For example, there is Argentina in Latin America, Myanmar, within Southeast Asia or Taiwan. For these countries and territories, separate applications should be done, and you also have to comply with the priority dates if the countries are of interest. The fourth disadvantage is, well, in fact, the PCT might give you at the end a longer time to obtain a patent. And why? It's also very simple and straightforward. It's under the PCT, the entry into national phase is foreseen after 30 to 31 months from the filing or priority date, and the overall time for obtaining a patent and patent rights in some countries might be longer. However, the applicants, you may request early entry into national phase, and this will help to give a boost to the processing. And the last disadvantage is the effectiveness of the PCT procedure, depending on the size of a company and also on the number of countries or jurisdiction of interest. And in some cases, it would be better, for example, if you aim at a few number of countries, not to take the PCT route, but this has always to be discussed with IP expert, IP lawyer. So now we will quickly see and switch to the international filing, the fees and how to file. Very condensed because a lot of things to say, but basically you have like a chronological chart taken from the PCT guide and also from the WIPO website. And basically you have what I was saying before, two big phases. The first one is the international phase. So the international phase, there are 5 stages, including filing, processing of the application, establishment of what we call the international search report and the written opinion. This is done by the international searching authorities that you have to select. Then you have the publication of the international application with international search report. And then you have supplementary international research and international preliminary examination. The first 3 stages occur automatically, but for all the international application. But the last two stages, international preliminary examination and supplementary international searches, are optional. So this is very quickly an overview on the international phase. I will be glad to spend some more time maybe later, but basically after this international phase, you switch to what we call the national phase. This happens at the end of the PCT procedure. Usually it's around 30 to 31 months following the filing date, the application date, or the priority date. And you want to start to pursue the grant of your patents directly before a national or regional, the patent office of the countries of interest. So the entry requirements into the national phase will depend on each state or designated office. And according to the respective national legal requirements, the applicant will have to pay national entry fees and provide also translations and also several local requirements. For example, there is China, the application must be translated into Chinese. The same goes also for India. Well, many local requirements that you have to carefully check also for this specific national phase. And as always, it is highly recommended to be helped and supported by a IP expert, IP lawyer. Notes, very important note, is that there will be no specific invitation to switch to the national phase. So it's really the sole responsibility of the applicant to start the national phase in due time. So you do not want to miss the deadlines, and of course you have to take care and pay attention to deadlines for the PCT. Therefore, it is strongly recommended to just familiarize oneself to get to know a bit more all the requirements and the deadline before the deadlines are even starting. So if we could switch to the next slide, please, Jim. Okay, thank you. So here's just to go a bit deeper with the PCT application. So you have, under the PCT, applicants have to comply with one set of formal requirements. It's a centralized procedure, and the international application will include the following elements. It's the PCT request, then you have the description, claims, one or several claims, the abstract, very important, and drawings. And I would also give you some more information about fees. The fees, well, PCT applicants generally pay, as it's mentioned on the slide, 3 types of fees when they file the international application. So there is what we call the international filing fee, then the search fee, which the cost varies between 150 to 2,000 Swiss francs, depending on the international search authority. And then most of the time there's a small transmittal fee, which also depends on the receiving office. To provide you with a bit more information on the application, the following requirements must be met for the receiving office to grant to give an international to set an international filing date. So the first one is that the applicant is eligible to file the application with the receiving office. The application is in the authorized prescribed language. The application indicates that it is an international application designating at least one PCT contracting states and containing the applicant's name, a description, and at least one claim. The international filing date will provide you with automatic and all-inclusive coverage of all states designations available under the PCT on this specific filing date. And because an international patent application is said to be effective in all the PCT contracting states at the same time, you do not incur at the filing stage of the procedure the costs that would arise if you have prepared or filed separate application before national or regional offices. So now we saw the international fees and how to file at international level. Let's go a bit, some quick overview on the international or the fees before some regional or national offices for the national phase. So it's here very simply mentioned, but in fact we have everything mentioned in our PCT guide developed with the EPO and the joint help desk, the international help desks. So here we can see, for example, Brazil. We can see several countries of Southeast Asia and also China and the different territories included within China. And every time you will have a table with the costs, but at the same time the documents which are required. So just for a reminder, Southeast Asia, you would have the costs and documents for 10 countries. Latin America, I think it would cover 14 countries. And of course, if you want more details, you can check the PCT guide. We also have a cost tool. There is, I know, also some tools developed by WIPO, or you can contact us, the IP advisor, the help desks. So there is one specific country which is not, unfortunately, was not inserted, which is not comprised in the PCT guide. So this is why I will take maybe a couple of minutes to share about India. So here you have the table with the costs, but do not feel shy. We'll be able to provide you also with maybe more details on this. And I just wanted to highlight some specificities in India. So in fact, in India, you will have first of all, examination fee reduction and priority when the Indian Patent Office is selected as the international search agency. There is a considerable fee reduction during the national phase entry. The second specificity is that dealing with the translation, like we saw for China and several other countries. The verified translated documents have to be submitted either before WIPO or before the Indian Patent Office. And if you do not submit on time, we mentioned that's very specific, the deadline and the requirements, it can result in a loss of rights. The third one is the amendments. The amendments, you have to make sure that all the amendments are directly covered either by claims described or shown in specification before the amendment. And again, deletion of claims is possible, but you will not be able to add some more. And the last one is concerning foreign applications, is that, well, basically you would have to inform the controller detailed particulars of same patent filed in other countries and update any changes of the application, in the application. This is extremely important, and it's mentioned in Section 8 of the Indian Patent Act. So this is all for me.
Perfect. Thanks a lot, Benoit. I think just before we go on to the role of the EPO by Camille Remy Boliolo, I think it's good to mention that in the chat we shared the link to the PCT guide that Benoit was also referring to. So I would strongly encourage all attendees to have a look at this guide, and you'll see in detail there some of the costs and procedures, filing procedures, per region and per country, even in Latin America, Southeast Asia, and China. Without further ado, it's really a great pleasure that we have with us today the EPO and Camille. Camille, the floor is yours to tell us a bit more of the role of the EPO and what role they play with regards to the PCT. The floor is yours.
Thank you very much, Jim, and let me thank the European Commission for inviting us to participate in this seminar today. It's a pleasure to introduce you to the PCT and the role that the EPO is playing there. And I'm Camille Boliolo, head of the PCT Affairs Department at the EPO since 15 years. Now, starting with this slide, I mean, Benoit did a great job, and Matthias as well, in introducing you to the PCT. I think this is very visual so that you can realize the extent of the protection that the PCT may bring to you. As an SME, it's a long journey to get the patent granted, right? And it seems like a complex thing to achieve. But actually, it's not that complicated if we take the basic steps in mind. First thing is the PCT is a first-to-file system. So the most important is to file your application with the receiving office and save your filing date. The filing date is what will protect you over the 20 years of the duration of the patent. And it's very important. It's almost the most important thing to do is really to do it right on day one. And for that, you submit indeed your application, as mentioned earlier, to a receiving office. The receiving office is not complicated. It's a patent office that is competent to receive your application. And which patent offices are competent? Well, the patent offices which are where the SME, so your company, is located, basically. So you just have to look at which patent offices may receive this application. In Europe, you have the choice between three. You have the National Patent Office, you have the European Patent Office, and you have the International Bureau of WIPO. So there are three different options available for you. The second step that is very important is the search. So you will get a search on your prior art in order to check whether this is indeed new and meets all the requirements to get a patent. So you will get a search and a written opinion on the patentability. This is extremely important to go forward with a procedure, because if of course it's negative, then you may either stop there the costs or amend your application. That is step 3 in the PCT procedure. And thereafter, the last step is of course entering into the national phases as mentioned by Benoit. This is done in the designated offices, so again, patent offices, where you wish to protect your invention eventually. Maybe you don't wish to protect in all these 153 member states of the PCT that you see on the screen at the moment, but you do wish to protect them, for instance, in 50 of them. Then it's relevant for you to understand that the strategy that you have during the international phase, the choice of the international searching authority that you will make, and whether you're working with regional organizations like the EPO, so with the membership that we have, and I will mention later, it plays a role, of course, thereafter in the national phases. Voilà, so what does the PCT bring to your patent filing strategy? As mentioned earlier, the multiplying effect. What does that really mean, the multiplying effect in up to 153? Basically, you are doing a number of actions, as I've just mentioned, and you're doing it once instead of doing it under the Paris Convention with each of the countries and the patent offices where you wish to protect your invention. So instead of going to 50 states in parallel, you're doing it only once in the PCT procedure, meaning you are reducing your cost because you pay only one agent to prepare this application. You're paying only one set of fees. For instance, you have only one language to publish this application. There are 10 official languages for the PCT, publication languages, as we say. Publication is very important as well, because in some jurisdictions, it's the moment in time when your application will actually get temporary protection, right? So the publication is performed by WIPO. And this is why you're paying, for instance, an international filing fee that is for the benefit of WIPO to cover the cost whenever they are publishing this application. Right, another very good thing, of course, is that of the PCT is that as an SME and even big companies, you don't really necessarily know where you want to protect your invention eventually. You're waiting for the search, you're still looking for investors, for instance, or you're further developing your product. So you need time to decide where you want to incur the costs, because there are costs, with which offices, with which countries. And that is very good in the PCT because you don't need to take that decision at the beginning. It's an all designation system, meaning when you file your PCT application, it is as if you would have selected all 153 member states during the whole PCT procedure, right? Up to the entries, of course, into the national phases where you actually are interested. If you miss the time of 30 months from the priority, then you would not be able to pursue the prosecution of your application in those national phases. You must meet the 30 or 31 time limit that is applicable before each and every designated office. But the good news is you're gaining, therefore, these 18 months of the international phase. And I'm mentioning this because the PCT is usually used as a what we call second filing system. So usually you would have your invention in your country, you would submit this to obtain a national patent before your national office to check on the first preliminary search, etc., to gain time. And then you enter into the international phase before 12 months. You're protected by the Paris Convention. So before 12 months, you can enter into the international phase and still benefit from this priority so that you're not killing your own prior art. Very, very important, as I mentioned. Filing date is very, very important. So you're protected by this priority. You have the 12 months of this first stage and then pursue the 18 months international phase. That makes 30 months, 31 months before you actually make up your mind as to where you want to protect your invention. Very useful. That's why we say that the PCT is gaining time, is gaining costs, and is an efficient system. Now, the next question you will have is, what is the EPO doing there? So first of all, what is the EPO, of course? The EPO is a continental organization in Europe. So as you can see on the screen, we have 38 member states. It's an international organization with a seat in Munich. Pretty much all countries of Europe are member states, with the exception of Bosnia and Montenegro that are in the process of accession. Actually, Montenegro will accede by the end of this year or next year. And then we have what we call the validation states. Validation states means pretty much like a member state, just that they are not a member state. They don't have a statutory status as a member state. So they cannot participate in the debate in the council, for instance, of our organization. But from a user point of view, it is really similar because basically the EPO is granting patents for Europe, right? And when we grant the patents, these patents need to be validated in each and every member state where you wish to actually have that patent taking effect. And that is true for our member states. It is true also for the validation state. So you just need to, after the grant of the patent, to pay a validation fee with each of our member states or our validation states in order to have that European patent taking effect, right? So that's the way it works. It's very relevant in the perspective that we have today, because it means when the EPO works as a designated office. So you select the EPO for the European phase, right? Eventually you will get, hopefully, a European patent. And on that basis, you could validate in all these countries that you have in the map that is shown to you right now. Now, in the process of the PCT phase, this famous international phase, the EPO is actually there to help you. It's a partner, right? For your consideration in order to support your strategy. What is very important is already to understand where do you wish to protect. Of course, you must be interested in Europe so that whenever you get your search, international search from the EPO, you could benefit from that when you enter into the regional phase. It will save you time and money, right? So that's very important. But it's also very useful if you want to protect in the world and in various regions of the world, because the European search, how to say, is considered as top-notch in terms of quality. What does that mean? It means that as much as possible, of course, you would have a search that would look at all the prior art existing in the world, in the patent documentation, as well as in the non-patent literature. And that is giving you some legal certainty, because it means, oh, okay, I have a search that tells me that my invention is actually an invention, doesn't exist somewhere else. I have some chances to obtain eventually my patents everywhere in the world. because this search by the EPO is very highly regarded by many countries around the world, right? And we have a lot of partnership with other offices around the world as well to ensure that this is indeed the case. And another thing for you to consider in terms of quality, just to understand why, from our perspective, the quality of the PCT search from the EPO is good, is because we're doing exactly the same work as we're doing in the European procedure otherwise. So if we park the PCT, forget about the PCT, you just want to protect your invention in Europe and to get the patent in Europe, you will go through a standard European procedure and you will get a search from the EPO as well, of course. Well, that search is exactly the same quality as the search that we do for our PCT applicants. There are two reasons for that. One, because the PCT procedure is very well integrated into the European procedure, which brings advantages for the applicants, of course. And the other big benefit for applicants there is obviously that the quality that we have at the level of the international phase is serving European users. 2/3 of our users, of our applicants that select the EPO as an ISA, are actually European as well, right? So we're doing the PCT international phase for Europe anyway, as a principle. Third thing, flowers in the garden. That's my preferred. You see some flowers behind me. Right, it's not a garden, but almost. The PCT system is based on an international treaty where there is a minimum set of services that must be done by an international searching authority, right? But nothing prevents an office to do more, to offer much more services than what is compulsory. And the EPO is also very good in this. So our garden is green, that's the PCT. And the flowers are planted by the EPO. That's all the extras that you get from the EPO. I won't go into the many extras, but you may find some of them in this guide that we produced together with the European Commission, of course, and further information that you could have on our website. There are some indications as well on the slide on the right-hand side. Good. This is just to show to you where, roughly speaking, the work is coming to us as an ISA. So first, the EPO works for 31%, more or less, of PCT applicants around the world. So as you can see, we are the #1 in terms of volumes, in terms of selection. Important, all receiving offices have selected the EPO as an ISA, but 6 in the world. Okay, so apart from essentially it's Canada and Australia and then some few small countries, but otherwise, and especially from the ones that are mentioned today, so India, China, Latin America, Southeast Asia, they have all, with some exceptions, Myanmar and Argentina are not in the PCT, so of course they could not select us, but otherwise they have all selected the EPO as an ISA. So it means if you file your application from those countries, you can select the EPO. Of course, as a European SME, you might file your application from Europe, in which case you of course have also the possibility to file with the EPO and select the EPO as an ISA. Right, so another important thing is, of course, keeping all your options open until you enter into the European phase. And then in the European phase, as I mentioned, you also don't have to choose with which countries in Europe you wish to protect your invention, right? It's only at the time of validation of the European patent that you will actually decide in which countries you want to protect your invention. Well, that's also the case with other regional organizations under the PCT. There is the Eurasian office for around 10 or 12 countries, Russia and others. You have also ARIPO and OAPI in Africa. Soon there will be, we hear, an IPR help desk from the European Commission in Africa, and we'll deal with those two organizations probably. Okay, then what happens when your PCT applications will enter the national phases is, if it's been searched by the EPO, then you will have a fast track. So it's very good if you're keen in going quickly, because basically on the basis of that, you don't have to do any further search at the EPO, you go direct into examination. If you happen to have done your examination already during the international phase, you get, of course, a high fee reduction as well on the examination fee. And yeah, in the course of 6 to 12 months, you could get your grounds, depending on your case and on whether you wish to have amendments to your application, right? That in that case, that could be longer. So I've put on the right-hand side there the benefits that this may have on costs, right? This saves you a lot of money. If the European has not done the search during the international phase, if the EPO has not done that search, then we will perform a second search when the file enters into the European phase, etc. It will take more time and be more costly. Okay, so that is something to consider, of course. Now the next slide, please. Thank you. And last but not least, so eventually, if you have a world strategy, right, you might be interested in benefiting from what we call the PCT PPH. So we have a series of bilateral agreements with all those offices that I've listed there on the right-hand side, Japan, Korea, China, US, Australia, Canada, etc. Where when the PCT applicant with a European Patent Office product, so search examination, enters into the national phase of those offices, you could accelerate your prosecution on the basis of the positive, if you wish, if the written opinion and the search were positive, and you don't amend your claims, so you keep your claims as they are in the international phase, then you could benefit from this acceleration process and get in those countries also very quickly a grant, right? So that's the top objective of all this long journey, is eventually to get a grant and be able to protect your invention in those countries. So I thank you very much for your attention. And now you see now, of course, all the links to more information on EPO's website and the social media. Now let me pass the floor to Jim. Back to you, Jim.
Thank you so much, Camille, for this very insightful contribution of the role of the EPO and some of the processes. I would now strongly encourage participants to share any questions that they might have. But maybe as a first question to you, Camille, you also alluded to the guide that we produced together, and some of those flowers, I think, in the garden that you mentioned. So additional services that the EPO offers. Can you maybe pick one or two of those additional services that are maybe especially of benefit to small and medium enterprises?
Yes, certainly. As I mentioned, very often the PCT being a second filing option, and SMEs in Europe will first file a national application. Well, in many cases, you would have, for instance, if it's in France or in Italy or in Belgium, Netherlands, and a dozen of countries in Europe, this search would have been searched by the EPO actually. By contract, we're performing the national searches of those countries. Or your first filing is actually with the EPO. We have quite a lot of EP Direct. So you're first trying to file in Europe an EP Direct application. In those cases, there is already a search by the EPO. So you enter into, and if you want to go further in PCT and go worldwide at 12 months, then you will enter this international phase, and eventually you will need an international search, right? Well, when the EPO is selected as an ISA, we will rely, of course, on what we have done already, that search that we have done already. This is what we call the doublure. So when you have that, you have lots of advantages. First, the fee is refunded, so you don't have to pay the fee for the search. We update it nonetheless, because in this time frame, there might have been more prior art popping up that was not at the disposal of the EPO in the first search, right? So you will get an enhanced, of course, search product. But more interesting, a real flower is that we have what we call the PCT direct procedure. You may send a letter to us and the application with track changes that you would have done with respect to the search opinion on the priority application. So the search opinion would have found some objections here and there to refine your application. Then you're filing your PCT a bit amended, and you explain to the examiner at the EPO what is amended and why and why you have amended it. This is very, very useful for the examiner, because the examiner then understands the logic and may perform a more efficient search as well. And therefore, you have more chances to get a positive search opinion already at that stage. So it's not a monologue, it's not a dialogue, sorry, it's a monologue. It's a chance for the applicant to already at that stage, right, very early in the procedure, when you file your application, basically, to be able to start kind of a dialogue with the EPO examiner and get more chances for a positive search opinion, thereby sparing yourself from a Chapter 2 procedure, from an examination procedure. Because if your search opinion is positive, you can go direct into the various national phases. Usually what applicants do is they wait for the international publication to take place, and then you can enter earlier into all the national phases. You don't have to wait until 30 months. The international publication is at 18 months, and if you are in a hurry, you can enter into the various national phases with your publication, your positive search opinion, your search, and have all the chances to accelerate the procedure before the designated offices. Now, this is an option, it's not compulsory. Other SMEs are actually happy to last all these 30 months in order to get more money, you know, whatever other reasons to make up your mind. So you're not forced, of course. You can benefit from these 30, 31 months and wait longer, right? So it's very open.
Yeah, perfect. No, that sounds indeed incredibly useful. And again, I can imagine that for attendees and SMEs, this is obviously a lot of information to take in. To also after this presentation to have a look at our guide and really feel free to reach out to either the EPO or to the International IP SME Help Desk with any questions you might have regarding this process and some of these also additional services that Camille just now referred to. Maybe a question for, I think this is something that Matthias Zuimendi can cover, our IP business advisor in China. There's obviously also utility models in various countries, and I know it's often in China there's sort of a dual strategy used with regards to patents and utility models. Utility models often being granted a bit faster, but providing quite a lot of coverage as well. Can you maybe share a few words on that dual strategy?
Yeah, sure, Jim. The main problem for patent registration here in China is that your company will get no protection while the patent is being granted. This means that during all the registration process that can go from 3 up to 6 years, you will have no way to enforce technology. This means that your technology will be published, will be available, but you won't be able to protect it. You won't be able to enforce it. So what some companies do as a strategy is to start a parallel registration of utility model and a patent, invention patent, because both types of intellectual property rights are pretty similar. They cover more or less the same aspects and they share the same requirements. But because utility models are going to be granted way faster, in less than a year, then you will have a way to enforce that technology while the patent is still being in the registration process. Once you obtain the patent, you just discard the utility model and keep using the patent. The problem with PCT is that you will be able to start only one of those types of intellectual property rights. You either choose invention patent or utility model. So if you want to use a parallel application, you will have to be careful in order to be very well coordinated and start both applications at the same time. So because you have to protect the novelty requirement. So if your company is actually planning to use a parallel registration in China, we normally advise to not go with the PCT application, but rather going with the priority rights and go directly with the CNIPA, the China National Intellectual Property Administration.
Thanks, Matthias. Actually, Camille, one more question for you just came in. First of all, the participant asks you for the very informative presentation. And the question is, if the EPO is selected as ISA or IPER, would the report include an assessment on the subject matter patentability? For example, an assessment on issues like computer programs or business methods.
Also, well, thank you very much for the question first. It's a good question. The example, the principle, yes, the example is slightly different. So I will explain. Yes, in the PCT procedure, so the ISA is establishing what we call the search report and the written opinion attached to it. It's also the case of the Chapter 2 procedure, where you have the international preliminary examination report, and inside you have the written opinion. So yes, there is an opinion on the patentability of the application. And that is done on the basis of what we call the PCT, International and Searching and Examination Preliminary Guidelines. So it's a set of guidelines under the rules of the PCT, which will determine to which extent is an application patentable, right? Now, there are a few exceptions because the PCT is a cooperation treaty. It's not a treaty to harmonize the patent law in substance. So you do have some areas where there is actually no harmonization in the world between, for instance, the US and Europe on business methods. Business methods are patentable in the US. They are not patentable in Europe, for instance, to use this example, right? The CIIs, to a certain extent, so computer programs as such are not patentable, but if they have a technical effect, that part is patentable. So it's more subtle, let's say. Now, how does that work when we work as an ISA? Well, we establish a search on the basis of what we can do, obviously. And generally, you have no more applications that are purely business methods. Nowadays, most generally, you know, it's a mix of something that is actually patentable with technical effect, etc., and there is a business method as well involved. So we would search what is technical in nature, and for the part that is not technical, we will just indicate that that part is not searchable, because we actually don't do that work, since we cannot grant a patent on that aspect, right? So it's very rare, extremely rare, that we actually issue a decision that no search at all can be performed. This happens almost never nowadays. There were more cases in the past, like 10 years ago, where purely business methods were applications were presented, but that's no longer the case. Even in the US, the case law has been more restrictive and has evolved. Is not yet at the same level as the EPO, but if you wish, has evolved in that direction as well. So I hope I've answered this question. It's a tricky question, but
yeah, it's a thanks a lot, Camille, and thanks also for the question. I think we're closing the end of the webinar, but maybe one final question for César. We've obviously discussed patents at length, but if we look at SMEs, how does a patent strategy or the importance of patents fit within sort of an overall IP strategy? How does it link up to the importance of having maybe a wider portfolio as an SME? Can you say a few words on that maybe?
Sure. Well, when thinking about patent, we normally think it as the big fish, right? And if we're speaking about SMEs, we should be speaking also about commercialization. And once you have this patent, you what have is something that protected the technical solution to something, which is pretty good. But it is not the same as saying that you have a final product, which is normally what you commercialize, absolutely protected. Thinking of this cell phone, this is good. This has more than 1,000 patents, at least in the United States. But does it mean that only with these patents are they fully protected? Absolutely no. They have the design, which is protectable as industrial designs. They have the trademark from the Apple, the software. Many other IP rights are involved, and all of them play a role in the final product. So you have to protect them all. You have to at least consider them, because if you have something that is absolutely unique and special, you may have the chance to protect that and have exclusiveness and hence an advantage in the competition level. But if not, at least you have to take a look in order to see whether you are infringing someone else's rights. So in any case, you just should have this holistic vision and see whether all these IP rights that may be involved are okay or not. And this is why our tools, our services are so good, because they give you the Google tool, the IP tool Googles, so you can really see how many and to what level are these IP rights involved. Does it fit what you were thinking
Perfect.
of?
Yeah, no, I think it's exactly true what you say. So also the layering of IP protection is important. Obviously, patents are incredibly important, but to combine it with trademarks, with copyrights, trade secrets. I think Camille briefly discussed business methods, for example. I think in certain countries that's something that could be covered under trade secrets, for example. So as an SME, be aware that it's not just about patents or trademarks, but there's various other rights that are incredibly important. And as César mentioned, we are there, the International IP Help Desks, to help you understand how to protect your rights and which rights are available or at your disposal to protect your product and your innovation. So without further ado, I would really like to thank all of the speakers today and all of the attendees. A special thank you to Camille from the EPO for joining us today, and obviously also for your great contribution to the guide that we jointly developed. To all of the participants, again, I would really like to stress, do not hesitate to reach out. We're a free service to help you find out more about intellectual property and how it applies in complicated third markets. Again, China, Southeast Asia, Latin America, and India. We're there to help you, so don't hesitate to contact us. And with that, I would kindly like to end today's session. The recording and the slides will be available on our website as of tomorrow. So for those that want to go back to the recording, you can do so. And with that, thanks to all of the participants and speakers again, and wishing everyone a great continuation of the day. Thank you very much.
Goodbye.